Good afternoon, everyone. I'm Collin Clibon. I'm the Associate General Counsel for the International Union of Painters and Allied Trades, and I'm so happy to get to talk to you today. So we're going to be talking about, independent contractors here in the context specifically in the paint industry. And just as a little bit of background, so I just want to acknowledge, that there's some tension in kind of looking at the way that law is currently when it comes to the tension between independent contractor status, traditional employee-employer status, and then also immigration law and how all of this works together as the organization that I represent is trying to raise wages and working conditions broadly. That being said, I would like to discuss, some of the way that we see the economy shaping currently, and then move into, ways that we can look at independent contractor status and its responsible use within the building trades. So just as kind of a primer in, how these kind of industries work, I just wanted to go over some slides, kind of how projects develop. So in terms of structure, a general contractor will have authority over a large job. And those general contractors then reach out to what are in our industry considered prime subcontractors to then perform certain trade-specific aspects of the job. That's where most of the signatory contractors that my union works with fall is under the subcontractor level. They're doing the paint work as part of a large project, paint, and also the allied trades, so also drywall finishing and glazing, putting in windows in large projects. These are the construction workers that my union specifically represents. And traditionally, within those trades, those workers would be unionized employees who were, well compensated and paid wages that could support middle-class, family-sustaining jobs. Across industry after industry, this model is breaking down, and there is a higher prevalence of an independent contractor model that, in this instance, is more exploitative and does not provide the kind of robust wages and benefits that historically we've seen in these trades. What I'm going to describe in the subcontractor model is something that's prevalent throughout the country, especially when it comes into residential. But what we're also seeing is that this is moving from the residential construction sector into the commercial sector, into the multifamily residential sector, and even into other areas. It's something that's growing, and you see the number of union-backed, high-wage, good benefit jobs in the building trades shrinking as a result. And one thing that I think it's important to acknowledge is not all independent contractor models are exploitative. Within the building trades, there is some tradition of small independent contractors performing this work in a way that is not exploitative, that allows them those entrepreneurial opportunities. I want to talk about ways that we can kind of harness the areas in the law that allows that, and move forward in this industry advocating in a balanced way that acknowledges the entrepreneurial opportunities that people want, but also provides the hard-won protections that come with traditional employment. So we've come to the point where we're talking about the prime subcontractors. Within what we've termed here the underground economy, you have a new layer, and that is what is termed a labor broker. Traditionally, they're performing more of the duties like you would see a traditional foreman on a construction site doing. They're giving instructions. They are, providing specific tasks to the workers and putting that level of control into the execution of the job. Below that level, the workers themselves are termed as independent contractors. They are paid through as independent contractors with a 1099 rather than a W-2. And this comes with a lot of different problems for those workers. Because of this structure, the employer, the nominal employer, the labor broker, is not paying for any kind of unemployment. They're not paying for any kind of workers' compensation. They're not paying any kind of liability insurance. They're not paying overtime wages as required under the FLSA. And because of this, you see widespread exploitation of these workers that work under these arrangements. So as you can see, as you work your way down, one thing I would mention is that the labor brokers themselves and let me take a step back. These employees, this is a cross-cutting area of discrimination. As we've heard, these employees tend more often to be exploited populations. They have a much higher chance of being undocumented, and paying them as a 1099 worker is something that is known and allows them to work despite undocumented status. And because of that undocumented status, those contractors will have a tendency toward exploiting them, paying them lower wages, making them work under under unsafe conditions because of that status and because of the risk that they run. One thing I want to mention here, and this is just to kind of open up a little bit more of the experience that we have working with the IUPAT. We're trying to work with these populations and try to make sure that they're represented in some way. One thing I'm very proud of is the way that we've been able to work in the deferred action space, and our organizers have been able to reach out to these communities and try to get people that are working in these spaces representation and get them protected status based on the Deferred Action for Labor Enforcement program. And we have had a lot of success getting these individuals work permits and allow them to have that legal status. Obviously, this is not a long-term solution to the immigration problems that we see in this space, but we're able to take this policy moment and try to help out the workers that are working under these conditions. So from there, we see this as being a model that's exploitative, and we can see that all of the benefits inure to the people that have the power in these situations. The prime sub gets cheap labor, and they push all of their liability down to the lowest level. The general contractor also benefits from that cheap labor. Developers benefit from that cheap labor. And another aspect is city and state governments are deprived revenue that would naturally come from the higher wages, that a fair wage would come for these workers, and also are deprived of the workers' compensation and the unemployment that should be coming out of this situation as a safety net for these workers that's just not being provided. Or if it is being provided, it's coming out of the low wages of these exploited workers. Now, that being said, not every 1099 model is exploitative. There is a long tradition in the building trades of having small shops that do work. And those kind of workers have a special status within the IUPAT. We have contractor members who maintain their union status, continue to pay into funds, and continue to receive union benefits despite the fact that they own a small shop. Another interesting legal analogy that we have been researching is looking into other areas of the economy where you have people that are in some ways like an employer and in some ways a employee. One example is, and this is an old case, but in the music industry, historically, there have been people that have been band leaders in some contexts, and they operated independently, essentially as independent contractors leading a small ensemble in some cases, but they would also play as a part of a big band. And in that instance, they would be an employee of another band leader, and they maintained their union status throughout those relationships, both as an employer and as an employee. So looking at those different areas, we have been trying to find ways not only to tamp down the spread of exploitative independent contracting use, but also trying to look at ways that we can take advantage of those, the ability of contractor members to shape wages and conditions, even in an independent contractor status, which independent contractor status is typically precluded from representation from a union through the NLRA. We're hoping to find ways that we can affect wages and conditions beyond a pure membership model. One example is, and this is just kind of one way that you can do it, if you look at the prime sub example, entering into agreements that if a prime sub subcontracts work, that that subcontract then has to be at a union scale. And although those 1099 subcontractors and those 1099 workers would not necessarily be union members, they would be getting union pay. And that's just one example of ways that we can try to work through organizing to get representation for those populations. I just want to close with, I think it's important to acknowledge that you have to have more tools in your arsenal than just going after policy solutions that call for a return to traditional employment. This is an area where we don't want to see the growth of this into new sectors of the construction economy, but we also have to have strategies that address the legitimate desire that people have for entrepreneurial opportunities. And this is kind of the good news story. So I'm working with clients across the building trades, and one thing that we've seen is encouragement of members to start small contracting firms that are union, that are responsible, and trying to find ways to support them and give them the ability to create these new opportunities for good middle class, family sustaining wages within the construction industry and move away from this more exploitative model. That really concludes my remarks, and thank you so much.